Now coming to section 11, what section 11 says, facts not otherwise relevant. The principle laid down in order that a collateral facts may be admissible as relevant under this section. There are two requirements: that the collateral fact must itself be established by reasonably conclusive evidence, and that it must what established afford reasonable presumption or inference as to the matter in a dispute. Certain circumstances, in a certain cases, the judgment in a previous suit to which one of the party in a subsequent suit was not a party may be admissible in evidence for a certain purpose and with certain objects in the subsequent suit. The circumstances are such that the crime must have been committed either A, B, C or D. Every fact which shows that the crime could have been committed by no one else and that it was committed by either B, C, D is irrelevant, except where there are judgments in rem or where they relate to public matter. Judgment not inter partes have been always held to be not res judicata, but they cannot be wholly excluded for other purposes, insofar as they explain the nature of the possession or throw light on the motives or the conduct of the parties or identify properly. Evidence recorded by one forum cannot be read in relation to the proceeding emanating from another form. Coming to section 12, the facts tending to enable courts to determine amount of damages. This section enables the court to admit any facts which will help it to determine the amount of damages which ought to be awarded to a party. When damages are claimed in a suit, the amount of damages is a fact in issue. Damages are a pecuniary satisfaction which the plaintiff may obtain by success in an action. They are limited to the loss which the plaintiff has actually sustained. Under this section, it may be laid down generally that evidence tending to determine, that is, to increase or diminish the damages, is admissible though not expressly involved in an issue. Thus, in an action or a breach of promise of a marriage, the plaintiff may give evidence of the defendant's fortunes. For it obviously tends to prove the loss sustained by the plaintiff, but not in an action for adultery, nor for a malicious prosecution, but the evidence of the amount of damages which is the necessary and obvious result of the defendant's breach of contract or his tort may be proved, though only alleged generally in a plaint. Where the plaintiff failed to adduce the best available evidence and this caused difficulty in assessing the damages, this was held to be no ground for refusing damages or fixing nominal damages. Now coming to section 13, fact relevant when right. The cases this section is intended to meet are those in which the right or a custom in question is regarded as capable of surviving repeated instances of its assertion and denial, where transaction may be supposed to have gone on modifying, asserting, denying, creating, recognizing it, or being inconsistent with its existence, leaving it after all that has been given in evidence. Fair matters of judicial consideration as to whether the court should or should not decree it. The right contemplated by these sections are plainly conceived as admitting of a proof by cumulative instances and transaction, and not by single and decisive and final way, namely the term of a document. The whole context indicates that the section is dealing with continuing rights which may be interpreted, which may be interrupted without being necessarily destroyed. The term right comprehends every right known to the law. It includes both corporeal and incorporeal right, including right of ownership. The section is not confined to the public rights, but covers private right also. The way in which property and its income have been treated has been held as relevant to consider whether it is secular or religious. The court also cited opinion of the Supreme Court as to what is meant by immoral custom. A phenomenon is said to be happening from time immemorial when the date of commencement is shrouded in the merits of the antiquity. Now coming to section 14, relevant of the facts showing the existence of any state of mind. This section declares that the fact which shows the existence of any state of mind means intention, knowledge, good faith, negligence, rashness, ill will and goodwill, or body or bodily feeling are relevant when such state of mind or body or bodily feeling is in issue or relevant. Intention, knowledge and similar other state of minds are matters of cognate inquiry in criminal cases. In some civil cases, they are very material. Example, in a cases of malicious prosecution, fraud and negligence, etc., where the question is as to knowledge, intent, motive or any bodily or mental state, evidence of other acts done showing the existence of such knowledge, intent, motive or bodily or mental state are admissible, even though it involves the proof of other crimes. Evidence admitted for such purpose must be confined within the limits for which it is admitted. The principle which evidence similar act is admissible is not to show that because the defendant has committed one crime, therefore he would likely to commit another, but to establish the animus of the act and rebut by anticipation the obvious defense of ignorance, accident, mistake or other innocent state of mind. Now coming to section 15, facts bearing on a question whether act was accidental. Section 15 deals with the relevancy of the series of similar facts. This section is an application of the general rule laid down in section 14. It is merely deduction from the more general provision of section 14. The series of acts relevant under this section shows a system where it is uncertain whether act was done with the guilty knowledge or intention or whether it was innocent or accidental. Proof that it formed one of the series of similar acts raises the presumption that the acts in question and the other together forming a series were done upon a system and were therefore not innocent or accidental. Coming to section 16, existence of course of business when relevant. When there is a question whether a particular act was done, the existence of any course of business according to which it naturally would have been done is a relevant fact. There are some illustrations. The question is whether a particular letter was dispatched. The fact that it was the ordinary course of business for all letters put in a certain place to be carried to the post, and that particular letter was put in that place are relevant. The question is whether particular letter reached A. The fact that it was posted in due course and was not returned through the dead letters office are relevant. Now coming to admission defined under section 17. Admissions are defined under section 17. An admission is a statement, oral or documentary, are contained in an electronic form which suggests any inference as to any fact in issue or relevant fact, and which is made by any of the person and under the circumstances hereinafter mentioned. The definition makes it clear that an admission is a statement in oral or written form, including electronic form like pen drive, disk, floppies, suggesting an inference as to the existence or non-existence of any fact in issue or relevant to the fact in issue. As already defined above, admission are statements that attach liability as inferred from the fact in issue or relevant fact to the party who made such statement. Statement denouncing any right should be conclusive and clear. There should not be any doubt or ambiguity. Now coming to section 18, 19 and 20. Who can make admission? Now section 18, 19 and 20 lays down the persons who can make admission. Section 18 says person who are related to the suit or proceeding, and section 19 and 20 relate to the third person. Admission by party to proceeding or his agent. Statement made by a party to the proceeding or by an agent to any such party whom the courts regard under the circumstances of the case as expressly or impliedly authorized by him to make them are admission. By suitor in representative character, statement made by parties to a suit, suing or sued in a representative character are not admission unless they are made while the party making them held that character. By party interested in a subject matter, person who have any proprietary and pecuniary interest in the subject matter of the proceedings and who make the statement in their character of a person so interested. By person from whom interest derived, the person from whom the parties to the suit have derived their interest is the subject matter of the suit or admission if they are made during the continuance of the interest of the person making the statement. Then section 19, admission by person whose position must be proved as against the party to the suit. The statement made by the person whose position or a liability it is necessary to prove as against any party to the suit for admission. If such statement would be relevant as against such persons in relation to such position or a liability in a suit brought by against them, and if they are made while the person making them occupies such position or is subject to such liability. Illustration pertaining to this: A undertake to collect a rent from B. B sues A for not collecting the rent from A. A denies the rent was due from C to B. A statement by C that he owed B a rent, he owed rent to B is an admission and is relevant fact against A. Admission by a person expressly referred to by a party to a suit under section 20. Statement made by a person to whom party the suit has expressly referred for information is in reference to a matter in dispute or admission. Illustration pertaining to this. The question is whether a horse sold by A to B is sound. A says to B, go and ask C. He knows all about it. Now C's statement is an admission. Now coming to section 21, when admission can be proved by or behalf of the person making them. Admissions are the best evidence as they always go against the person making them and relevant as long as they are against the interests of the person making them. But section 21 lays down an exception as to when the admission may be proved by or on behalf of the person making them. Admissions are relevant and may be proved as against the person who makes them or is representative in interest, but they cannot be proved by or on behalf of the person who makes them or by the representative in interest except in the following cases. An admission may be proved by or on behalf of the person making it when it is of such a nature that if the person making it were dead,